Good morning. We are here for case number 23 JV 53, people in the interests of Austin Carver, Apollo Elder, Artemis Elder, children, and concerning Vicki Alford, Austin Elder, and Hunter Carver respondents. Ms. Schaefer appears on behalf of the people. Ms. Alford is present. Our guardian ad litem, Ms. Coleman, is present. Ms. Homer is here for Mr. Carver. Mr. Baker from CASA is present. Mrs. Westberg is present from the Department of Human Services. We are set this morning for a continued hearing on the permanent placement order. Before we get into that, as you all know, there was a status of council hearing that was held yesterday, April 16th. At the conclusion of that hearing, I did determine that there was an irretrievable breakdown in communication between Ms. Groom and Ms. Alford. Ms. Alford expressed the desire to proceed pro se. I did determine that she had the ability to do that and did allow her to do so. However, I also appointed advisory council, letting Ms. Alford know that at some point, depending on what occurs, that advisory council perhaps would be stepping into the role of council as opposed to just advisory council for her. The person that has been contacted for that role is Brian Conklin. Unfortunately, Mr. Conklin couldn't be here this morning, but he is anticipated to be the person that would be Ms. Alford's advisory council. And he's willing to do that, and we're getting that arranged for that, but we couldn't get it between yesterday and this morning to get everything in place, and he had a conflict, so he couldn't be here this morning. There was also a hearing held on Monday, April 15th, that was specific to Mr. Elder. This hearing is specific to Ms. Alford and Mr. Carver, and it was continued from last week so that we could finalize the permanent placement order. There was also a request to address parenting time and how much parenting time Ms. Alford was having. I did receive a notice of a position from Mr. Yorko, who is the person that represents Mr. Elder, indicating that there was no objection so long as the parenting time continued to be supervised. I also did receive the document from Ms. Coleman indicating that she was objecting, I believe, Ms. Coleman, you're going to correct me if I'm wrong, that I believe was objecting to expanded parenting time, and there were some family members that were going through some training, and once that training was completed, didn't have an objection to them being supervisors. Did I get that correct, Ms. Coleman?
Yes.
Okay.
And I believe DHS is in agreement with that as well.
Okay. I wanted to clarify, is there an objection to expanded parenting time so long as it's supervised, or is there an objection to any expanded parenting time unless it's supervised by family members?
No, I object to any increase in time based on the PCI that I filed as a proposed exhibit.
Okay. So I'm sorry, then I'm a little confused about the link between if family members receive a particular training, then you don't object. I guess
to them doing the supervision instead of professional supervision. I think that's how this came about, at least from DHS's side, because of the change in the law of the family time bill, that we're supposed to try to get family supports in place to supervise, so I don't oppose them supervising.
Okay.
Instead of Ariel.
Right.
Okay.
There's a however, though, there's some training that the Department of Human Services requires of kin prior to taking over that supervision piece. It's my understanding that Ms. Carver's stepmother, I believe, is that right, stepmother?
Yeah.
Okay, thank you. Has now scheduled that time to meet with Sarah St. Martin over at the department. Until that occurs, and we get the go-ahead from Ms. Martin, we'd ask that it stay at Ariel for the 2.5 hours that are currently in place. As soon as that training is done and we're good to go, then the grandparents would supervise the visits.
Okay. When is that set up, and how long is the training that we're talking about?
I don't believe it's very long. I'm sorry, I'm pushing the button.
Yeah, don't push the
Sorry. I don't believe that, I'm not sure exactly how long the training is. I think it's just one session essentially to go over like what to watch for, when they may need to step in, if there's anything they see that needs to be reported, things like that. I can't tell you for sure exactly how long that training is, but I think it's just a one-time session. And I know that there was communication between the step grandmother this morning and Sarah St. Martin to schedule, and they were going to try, I know Sarah St. Martin was going to try to get it in within the week and try to get that done.
Okay, so understanding you don't know how long it is it your understanding it's not like several sessions that go over weeks, it's just one
No.
time?
I believe it's one, maybe two, but just one, and it's like maybe an hour or two at the most.
Okay.
So,
All right. Ms. Alford, I know that we talked about addressing expanded parenting time or family time this morning. I'm a little loath to do that without you having your advisory council with you. We do, however, need to address the permanent placement motion that has been filed, and ultimately that permanent placement order. So those two things are two separate things to me. There does need to be a hearing held on a request to expand parenting or family time. That, however, again, is separate from that permanent placement order that is required by the statutes under 193702. So I am inclined to address the permanent placement order issue and set a hearing when Mr. Conklin can be here with you for expanded parenting time. So that's my inclination. So you tell me your thoughts, and then I'm going to go around and ask everybody else theirs as well.
Regarding the increase in parenting time, I did file a response to Mr. Elder's position. I sent it into the e-filing system and shared a copy with all of the parties. And I also printed out 4 copies in case you'd like to see that.
Yeah, it hasn't made it into the file yet, so I don't see it.
Okay, can I submit it now?
Yes. And has anybody else seen it at this point? Okay, so.
I have.
Oh, you have? Oh, good. Okay. That's good, because there's copies here for everybody else here in the courtroom. But
Can I approach?
yes.
thank you.
Thank you. Awesome. Okay. And I do have a copy of the response to Austin Elder's position on increased parenting time. It's a couple of pages long with attachments. Go ahead, Ms. Alford.
Last night we received the domestic violence assessment, and the conclusion, which I attached to the motion, the conclusion made by Ms. Chrissy Stevenson at Hilltop was that Mr. Elder, he made it to be extreme danger, level of danger to me and the children. I think his number was 22 on the danger assessment score. And so I'd like to request that the court take that into consideration, especially since Ms. Coleman had appropriated unlimited unsupervised parenting time for Mr. Elder, like right after the adjudication trial, I'm assuming. I wasn't made aware of this. I wasn't given the opportunity to give my input on the issue. And I'd like the court to also take that into consideration with regards to the allegations of bias and yes, allegations of bias and not being impartial, as it is very contradictory to the children's best interests as well as hypocritical, in my opinion. And as far as the permanent home orders go, I am still objecting to Mr. Elder's family being the permanent home, but more importantly, I think we need to address the issue of little Austin and his prospective permanent home. My parents have expressed their willingness and desire to be the permanent home in the concurrent planning for this case. For some reason, their desires go unacknowledged. They've offered to be kinship placement as well, which has gone previously unacknowledged by Miss Murillo when she was in charge of the case, which I'd like the court to take notice of as well. But I think that's the most important issue, is making sure that Austin has a concurrent permanent home with people that he knows and loves and who is blood related to.
Okay, give me just one moment. So has there been, I'm looking at the Family Services Plan report that was filed in this case on March 29th. It talks about family search and engagement and that it remains ongoing and that there were 2 ICPCs regarding paternal aunt in Texas. Has there been anything with respect to Ms. Alford's?
Yeah, and I can tell the court that May of 2023, caseworker Canetti called and spoke to Mr. Alford, grandfather, and at that time he indicated that they were not in a place where they could take the child. If his position has changed, we can certainly begin that home study process and look at that, but at that time, they were not interested in being a placement option. He said he was not in a position to be placement. So that was part of the process back in May. I don't believe we have found the family in Texas has engaged. That has been a continuing concern. They were initially engaged and obviously testified at the adjudication hearing. But kind of since then, I don't believe that they've been engaged with getting that home study done. They had completed one in the prior case for Austin, had been approved, but then we'd returned Austin home, which is our obligation at that time. But then they didn't re-engage to do a new home study, and I think it would have just had to be somewhat of an update. They just didn't do it.
Okay. So, Ms. Shaver, anything else on the issue of well, first of all, I guess 2 things. Anything else on the issue of a permanent placement order and any issue between addressing that and then coming back for a hearing on parenting time or family time?
Yeah, and I certainly don't object to coming back for a hearing on family time if Ms. Alford needs to have that advisory counsel for her. That isn't a problem. In the meantime, I think we're going to proceed forward with grandparents doing their training because I think that is our statutory obligation, and hopefully can move it over into the grandparent visit so that really what we're going to be looking at then would be an increase in that supervised family time with the grandparents. As to permanency, 193702 addresses that permanency, and as the court knows that we have to make a determination of whether we are continuing to look for that permanent home. And I think that continues to be ongoing. It's my understanding that I think the current home is, for Austin, is willing to be permanent placement, or are they not? No, they're not willing to be permanent
To my
placement.
knowledge, they're not willing to be permanent placement at this time, so we would be looking for a concurrent home. outside of they're willing to keep him as long as needed, but not concurrently.
Right, so, and our obligation is to continue to look for family placements, and so we will, if Mr. Alford is amenable to being placement at this time, we'll look for home studies and start that process. As to the littles, they've been in that home almost since we were moved. I think they may have been in a different placement briefly. They've been in that home, are very familiar with that home. There's no reason to believe that that's not a safe and appropriate home for the children. It is kin home. It is an obligation on us to look for kin. They are appropriate, and as a matter of fact, at this point in time, we had transferred legal and physical custody to these individuals because we were not going to, they were not going to go through the process of being certified, so we were obligated to do that. But, the statute says whether ongoing efforts have been made to identify kin and relatives that are available to be a permanent placement for the child or youth. That's the case. These people are kin and they are willing to be permanent placement for these children. So we have met our obligations. There would be no reason why we would move these two littles from a placement where they are safe and secure at this time.
Ms. Fuller?
Thank you, Judge. And so I am familiar with the two relatives residing in Texas who would like to be placement options for Austin, the child Austin. I've communicated with them during the course of this case. My understanding they continue to want to be placement. I will check in with them and see, why there hasn't been communication between them and the department. They did finish the ICPC process in the last case and were approved. So I think that there is a very good chance that Austin could be permanently placed with family if need be. With regards, and I know we're not handling that specifically today, the restriction on parenting time for Ms. Alford, I would just say that the statutes are very clear with regards to treatment plans and the ability of other parents to weigh in on those. I would consider this family time a part of that, certainly along those same lines, and do not believe that he should have the ability to object.
I was with you until that last statement, Ms. Fuller. So it sounded like you were indicating that he being Mr. Carver, should have the ability to weigh in on the issue, but that he...
Mr. Elder, the father who responded to the people's motion, or to Ms. Alford's response.
Well, he hasn't responded to the response. He responded to the request.
So in response to the request, I don't believe that he, just given its extensive case law that indicates that other parents should not have the ability to determine these types of things.
Okay.
And I think Ms. Fulmer may not understand, we're not asking to restrict family time. So that's the part that I don't think she understands. We've not filed any motions to restrict mom's family time. So this is whether her family should be providing that supervision and whether there should be an increase in family time.
And if I misspoke, I apologize. Then the increase in parenting time, and so that was the objection, I believe, by Mr. Elder.
I don't think it was objected to that.
Ms. Coleman?
Thank you, Your Honor. I'd like to first know if we're having the hearing on increased family time, because I do have a witness there that I'd like released from his subpoena if we're not dealing with it.
We are not dealing with it.
Okay, then if Mr. Shealy is in the courtroom, if he can be released.
There's somebody smiling and nodding, so I'm
Do we
guessing
want to
that's-
just have him wait until we reschedule that portion so we don't have to reissue a subpoena?
Well, it's up to him. I'm happy to send him a new subpoena within a day.
If you want to go, you can go. She'll send you a new one. That's all right.
Okay. You're good? Thank you. He is leaving at this time. Thank you.
Oh, increase.
Thank you. And I'd agree with Ms. Shaver about the permanent home determination. I think the Littles are in a permanent home that's best for them. That doesn't mean we're not looking at return home at all. I also echo Ms. Alford's concerns that really the focus here should be on little Austin. I'm concerned that he's not in a permanent home, although we did just have an administrative review right before this hearing, and it was indicated that could be a permanent home. So I think we need some clarity on that. But I think that's really the concern is, like Ms. Alford said, there isn't a backup option for him right now, but I'm not sure that's true.
Okay. Anything else, Ms. Alford? On the issue of the permanent home issue?
Yes, on the issue of the permanent home, I would like to make a record. My safety concerns for the babies living in that home, if they were to be ordered as the permanent home, is that they live 104 feet away from a man who was just recently convicted as a child sex predator, child sex offender. That's a safety risk. It's a huge safety risk for me. Also, Artemis and Apollo do not have their own rooms. They don't have their own spaces to live in. They do not have their own beds. They've been co-sleeping with Krishana Elder and her boyfriend Steve Willie this entire time. And they live in a 432 square foot home. They only have a 1 bedroom. And so I truly feel like that's not the best place for the babies to be living if reunification was not an option any longer. Mr. Elder has a copy of the.
It appears, and Judge, I do believe that a copy of Miss Alford's capacity to parent evaluation was submitted on ISIS. I believe that was submitted to all the parties. I received a copy of it, and I represent Mr. Carver, obviously. Miss Alford is a victim of domestic violence, and it would appear as though Miss Coleman has distributed her capacity to parent to Mr. Elder.
And I think the court could maybe enter protection orders. I obviously distributed it to Ms. Alford's attorney at the time, Ms. Groom, and the guardian ad litem, because that's my obligation. And then I received the one from Mr. Elder, and he got it with his attorney as well as Ms. As the guardian ad litem. So that's where those went to. That Ms. Coleman chose to distribute it. That was up to her if she feels it is appropriate to do that as evidence. And I think if evidence is provided to a court, everybody's going to see it. That's unfortunate, and that's unfortunate through the process.
Anything else? Ms. Baker, I know that you're here. I haven't come over to you. I didn't know whether you had any positions on the permanent home issue or not. If you do, you got to come up to the podium, and if you want to make any statements, you can.
In my visits with the children, and I observed the little's time at the elder home, and they are very comfortable there. It's a very good space. They have wonderful places to play. They are very, very comfortable. I watch them play and engage. So I would echo it's been the system. I'm concerned about a change in their lives right now. It's been very good. One of the things that's also been happening on the weekends is Big Brother gets to come in and see them, and he loves playing with his little brother and sister. So it has been a very good place for all of them to interact. I have gone to the current placement for Austin, He really enjoys it there. I was with him last night, and he commented on the things that he does, and his teacher, he's been doing very well in class, and all those things going on. So, and they make sure that what he needs, he has. So in that respect, the permanency for the littles right now, I would echo that. I would push for that, to get that taken care of, because they don't need, it's an expedited aspect of it, and we want to get that done. I would like to see some concurrent with Austin, but his ability to go and visit the littles is very important to him. So we want to keep that, and having all that settled for them in a familiar way is important to him. That's okay. Thanks.
Thank you.
Can I make a record? Can I ask that there's a protection order in place because the capacity parent was shared? There's HIPAA protected information in there that shouldn't have been shared.
Oh, I'm going to enter a protection order.
Okay, thank you.
So, yes. So I note specifically with respect to the permanent placement order that has been requested, I do note that pursuant to 19.3.702, that a variety of things have to happen. A permanent home is defined in that section. It also talks about timing in that. Ultimately, a permanent home is a home that is determined by preponderance of the evidence. Ms. Alford, I think you have some understanding of preponderance of the evidence because it was something that we talked about during the trial itself. And that just means that it's more probably true than not that this could be a permanent home. One of the struggles always is what that means, and there are requirements under Title 19 that require a variety of things to happen in certain timeframes, and of course 12 months is the time frame for this. Ultimately, based on all of the information what I consider the exhibits as far as the family services plan, the social history, those kinds of things. I do find that at this time there have been reasonable efforts, but there hasn't been a permanent home that has been determined for Austin. With respect to Artemis and Apollo, there is a place that could be a permanent placement, depending on what happens in the future. The order has certain language, and we talked a little bit about language yesterday when we had the status of council hearing, and the importance of that language. What I'm going to be doing is I'm going to be entering a permanent placement order. However, I'm changing the language that is there. So what I'm going to be ordering is that if the children are unable to be reunited with a parent, so that's number one, if an alternative placement is not found that would more appropriately serve the best interests of the children, or if the parent-child relationship is terminated, then the current placement would be intended as their permanent placement. So what that does is that allows there to be a finding of a permanent placement at this point, and it leaves open the possibility of a different one, okay? So that's what I'm going to do in this order. So because I do find that it's appropriate to enter something at this point, and that if other things don't happen, this may be where they need to land, okay? So with that change, again, I am entering the order that have been filed. The order, okay, there has been a hearing scheduled for a review of this order with Mr. Elder for June 17th. So I'm going to schedule a hearing around that time for you and Mr. Carver as well. We're also going to be talking about a hearing for increased family time. Because Mr. Conklin isn't here, I hesitate to schedule that at this point because that's difficult. So what I've done is I've gotten a time for y'all to call in, and then it can be scheduled with the division clerk. And that time is Friday, April 19th, so this Friday at 11 o'clock, okay?
That's a birthday.
So I'm hoping that everybody can either be available or have their calendars available at that time so that then there can be a hearing with respect to increased family time. For Ms.
Your Honor, I'm starting an APR hearing right at 11 that day.
Okay, it can be 11 or later.
I could do any time afternoon.
Okay, so then let's change that time to, you said afternoon, do you mean after 12 o'clock or in the afternoon?
It's just set for 1 hour, so I can
Okay.
do it at noon.
Okay, no, I'm not gonna have it, I just wanted to make sure I was clear. So how about doing it at 1:30?
That would be great.
Judge, I'm in a shelter hearing beginning in 1 in Delta County. I expect I could have a break by 2:30 for a setting, and I don't have my paralegal available on that day.
Okay, so 2:30. 2:30 work for everybody. Ms. Alford nodding. Mrs. Coleman's nodding.
I have people, so we're gonna do it.
Ms. Schaefer then is nodding. Okay, so 2:30 on Friday, April 19th. Call into the division clerk. Ms. Schaefer, will you do a notice?
Yeah, for the good that does 2 days before.
I know, but at least it's there and hopefully it will go out to people. As stated, I am entering in a protection order, and I'll do this in written form, but I'll do it orally at this point. And that protection order is going to preclude the distribution of that parent-child interactional assessment to Mr. Elder. If Mr. Yorko needs to talk to him about things, Mr. Yorko has it, but Mr. Yorko is going to be precluded from giving a copy of that to Mr. Elder. I do find certainly that that's...
And I just emailed Mr. Yorko to let him know not to send it back.
Yeah,
Hopefully
so
he has it.
it's not going to go to Mr. Elder. If they need to talk about something because things are coming up, they may talk about it, but he can't have a copy of it. Okay? So that'll be the protection order in place. And again, I'll issue a written order that says that.
Your Honor, I'm requesting that study, both parent studies, actually, never mind, just mothers, be given to Mr. Sheely, Little Austin's therapist. I think it would help in his therapy.
Ms. Alford? And actually, don't answer that. I'm going to require that you give me something in writing by within a week, so that you have an opportunity to talk to Mr. Conklin. Okay? So a response to the request to distribute that to Austin's therapist no later than April 24th. April 24th. So I'll get that response and then I'll rule on that request, Ms. Coleman. And anybody else who has a response to that, please file that by April 24th.
The people will not be objecting.
Okay. All right. I do want to go ahead and schedule a review around the time that I scheduled the other review with respect to Mr. Elder. And I'm thinking I'm doing this so far in the future and it's not a terribly long time that Mr. Conklin, even though he's not here, we can go ahead and get that done. So I'm looking at Thursday, Thursday, June 20th at 8 o'clock.
Yes, Your Honor.
Me as well, thank you.
Yes.
Okay, thank you, Ms. Coleman. Ms. Alford?
I'm still looking.
Okay,
How long is it going to be for?
set for half an hour.
Okay.
It may be less than that, but it won't be any longer.
Okay. You said 8 o'clock?
I did.
That's perfect.
And what kind of a report would everybody like?
That, I think that I required the narrative.
Okay.
I don't remember the language, so I'm sorry.
Okay.
So whatever that is that you would do for we talked about for Mr. Elder, the same thing for this. So I think that's the narrative. Is how that is. Okay. I think that addresses everything at this point. Ms. Shaver, did you have anything else?
No, I don't think I do, Your Honor.
Okay. Ms. Coleman?
No, thank you, Judge.
Ms. Alford?
No.
Ms. Coleman?
No, thank you.
Mr. Baker? Okay. All right. Then I will for sure see you on June 20th at 8 o'clock, and we'll have a hearing between now and then to address the issue of parenting time. You'll be getting some orders. One thing, Ms. Alford, I need to make sure that we have you in the system so you're getting things. There is, I think there's a form downstairs that you can provide so that you can get email service or you can get it by mail. But what do you think you're gonna be?
I prefer email service. I'll go downstairs and check that out.
Can you tell me your email address?
Yes. It's VASILEIXX@gmail.com.
Okay. VASILEIXX@gmail.com.
That's correct, Judge.
Okay. If you can fill that out, please still do. We get a form downstairs just so that we have it, so in case I've written it down wrong or something. We make sure that we get it right, so that it'll come to both you as well as Mr. Conklin when things are served.
Okay, will do.
All right. I will see you soon and certainly no later than June 20th. You'll be getting an order, a variety of orders here. All right, thank you.
Thank you.